Hello everyone, it's so lovely to have you here on this beautiful Thursday morning to our webinar. We had a huge amount of people that said that they wanted to join us today, so we're really happy about that, and it's obviously a topic that is really relevant in the industry at the moment. We're seeing a lot of people talking about it on Facebook groups, sending us questions, so we just thought, now would be a good time to discuss this topic, which is how to plan and host a legally compliant AGM or SGM. So I'm just going to introduce our speakers today. So we've got Willie Roos, who is the CEO of Stratafin. Willie has practiced as a property attorney for over 20 years. He has been involved in sectional title management for over 8 years. Willie started Stratafin in 2014 with the ultimate goal of assisting bodies corporate with their funding without catching them in a debt trap. So Stratafin strives to be a fair and equitable money provider for the sectional title industry. And Willie has built up Stratafin from its inception to today, where it has debtors under management of over 300 million rand. Stratafin have partnered with Medu Capital, and the PIC has invested with a 45% ownership. Shirley is our guest speaker today. Shirley Baillie, she is the owner of Baillie and Associates. Shirley's passion has been and still is the sectional title industry, and her mission is to educate those working with it or living in it. This especially applies to the owners and trustees with regards to their rights, duties, and responsibilities, and gives them at least a basic understanding. Shirley has 38 years in and around the industry, meaning that she has a thorough understanding, enabling her to bridge between the legal and the practical, and this is a huge asset in her training. Shirley created a popular book, Keyword Access to the Sectional Titles Act, which is a big hit in our office. Everyone's fighting over it all the time. And this allows owners and trustees to access and readily, by means of a detailed access of all keywords or topics. The Keyword Access to the Sectional Title Legislation Manual is now in its 14th year. I'm going to hand over to Shirley, and she'll take you through what is an AGM.
Good morning, everybody. It's amazing that there's such a good turnout, and I'm very happy to be here. I want to have an analogy for an AGM. I believe that the AGM is terribly important, and you can align it to the fact that without a backbone or a spine, a skeleton has no use at all, because you have to have something to hang on the parts of the body onto the backbone or the spine. Now, this is exactly what an AGM is about. It's key, because if the AGM doesn't take place correctly or doesn't take place at all, there's nothing that the body corporate can do thereafter. It's absolutely stuck in a hole. So to me, the AGM is really important. It's like the spine of a body. So having said that, I'd like to say that the AGM has to be conducted correctly. It takes place once a year. There's no excuse for it not taking place. I hear lots of them from, the financials weren't ready to, well, we had COVID. So, okay, that's about the only excuse I'm prepared to give consideration to. But there's also no reason why you can't have it virtually. Now, a special general meeting is sometimes confused with a special resolution. A special general meeting is a meeting that's anything other than an annual general meeting. Because the annual general meeting is only one a year, and the rest of the year there may be times when you need to meet up. Now, a special general meeting can just be an ordinary meeting, that there doesn't have to be any major consideration take place. It might be to get together, for example, where you've had a trustee that's not been performing and you actually want to vote him off. Now, you do not have to have a special resolution for that. You only have to have a body corporate resolution. But so it's a special general meeting, but not with a special resolution. Now, if you have a special general meeting with a special resolution, the type of things that you need to have special resolutions are many. But one of them is if there's going to be an extension to a section, or there are more risks that need to be involved relating to insurance, or improvements to the common property, those type of things. So you need to get together to have the special general meeting, put out all the information that's necessary for the owners to make a decision and vote for their special resolution. Okay. The notice period's also important. AGM 14 days. Yes, that's fine. If you can give more notice, that's also fine. I have to say that we're doing virtual now, so it's not such an issue, but I did find in the past that there were a lot of holiday blocks of flats, and people would come down to the meeting, so they needed more than 14 days. So we actually put in our conduct rules that, in fact, it was 30 days notice for the AGM. But that's not relevant anymore, but I'm just mentioning this in case of. And then the special general meeting needs to be given 30 days for special and unanimous resolutions. The urgent matters, well, I heard about them from Willie yesterday and Daniela. I didn't realize that they're just in the middle of this whole thing, because sometimes people have to have an urgent meeting because maybe they don't have money to fix something like a huge water burst. For example, one of our buildings, the side slipped, and the 4 people had to leave, and we needed to claim for insurance, but we didn't know how long insurance was going to pay out. So to borrow money for that, you need the owner's resolution to actually go ahead. So yes, it can, if it's an emergency, you can call it under 7 days. And you do know, I'm sure all of you are aware of it, whether you practice it or not is a different story, that you must have the AGM within 4 months of each financial year. And that means a bit of pre-planning on the managing agents, because they can't wait till the last minute. And if you've got an AGM that's in December, maybe the auditors go off on leave. So they a good reason why you can't get it done. But there is no reason why you can't have it. You can even, but it's very important that you get the annual financial statements audited and out. We are going to mention it a little bit later. So who should receive notice? Well, anybody that's got an involvement, from the bondholders of those people who need bonds, to the developers holding future right developments, and the managing agents need to get notice. And yes, the managing agents normally send it out, but sometimes the trustees don't like the managing agent, so that they then invite the managing agent to come and do their own. I haven't heard about it ever happening, but that's what the Act says. Then the other thing is getting it to those people. You have to have prepaid registered post to the section, or another address that the owner might have nominated as domicilium, or you can hand deliver it. But it is really important to understand it can also go by email or fax, but that's in addition to. And I would also recommend that it's sent out by fax and email. I don't know that fax is being used that much anymore, but definitely email, because post is not that great, and sometimes people are not at their residence. So double your tracks and make sure you send it to both places. That's the way you're going to get a quorum. Okay. The Act is very clear about what should be included in the pack. And let's start with the AGM and the SGM agenda. Very clearly needs to be set out. I sometimes wonder, the people that send out agendas actually don't even read the Act, because there are things missing. And yes, it could be a typing error, but that should not happen. You have to be very careful that you have included anything else. And someone's just come through with a question. You can nominate your email as the domicilium. Yes, you can, but it needs to be in writing. I do that because I travel a lot. The minutes of the previous meeting, if it was, you haven't had a special general meeting since the last AGM, your last minutes will be the last AGM minutes. If you've had one in between and you've had a special general meeting, at the special general meeting, you would have approved the minutes of the previous AGM. And then then you have an AGM, then you approve the minutes of the special general meeting that was held before. So it's already always the immediately past minutes of the meeting. Trustees' reports are critical. This is where probably owners for the first time know what's going on in the last year. Really important. the more detail you give, the more transparency there is, the more relevant it will be, and you'll get a lot less questions as chairman if you put out all the information. Also going to be done in more depth. Annual financial statements have to be signed by the trustees and by the auditor. 2 trustees, that's how it is. But sending out annual financial statements that are in draft form or not signed by the trustees because they say, oh no, they want the body corporate to approve them. That is not on, because the trustees are responsible for seeing the financial statements are done. So your auditors sending out draft financial statements are not taking responsibility for it either. So if you come to an AGM with a set of annual financial statements that is not signed by either the auditor or the trustees, you're wasting your time. You can't approve them because owners don't know what's going on. And the auditor's financial statements give a measure of support and credit to those. Proposed budget really is key because it's part of what's going to happen in the future. And please remember that the proposed budget is not, it's about doing it properly and getting all the costs for everything that is likely to happen. And then saying, working that back to the percentage levy increase, not the other way around, that you as the owners or the trustees decide, we're only putting up our levies 5% this year. So what can we afford for 5%? That is the wrong way around. You're actually shortchanging yourself. You're not doing things in terms of your mandate, and that is not okay. 10-year maintenance plan, a really important aspect. In fact, the auditors have to report if it has been correctly done and it is available. I always suggest that a 10-year maintenance plan should be done by a professional in the industry because they make sure that everything's covered. With great respect to trustees, they're obviously very subjective about what's going in there because it's going to affect their pockets. Because if there's more things that go in, the levies are going to go up. And that is not the right way to do it. So get somebody that's objective, because these trustees also don't have the expertise to actually put it together correctly. I've even seen in the 10-year maintenance plan produced that they've put in running costs like the servicing of the fire extinguishers in the 10-year maintenance plan. That is not on. That's in your admin levy. Insurance valuation is critical because if you don't have proper insurance, you have potential huge risk of loss. And it has to be done every 3 years now by a professional valuer. Schedule of replacement values and also proof of fidelity insurance, public liability, and any other insurance that may be needed. Insurance is key, and we're going to hear from Willie later on. Proxy form, you only may serve as proxy for 2 people. That's it. So the days of giving proxies to the chairman so that he sits with 40 and completely controls the meeting are far gone. Nomination forms, really critical. They need to be signed by both parties. And yes, I know people stand up at the AGM and say, oh, let's propose so-and-so. But you know, that's spur of the moment, and that gets you into trouble because people who stand up at the AGM and propose somebody else, the person says in the moment, let's take it. Much better to have nominated forms that people have considered. Then voting cards, which is also supposed to be part of the pack, is kind of a little outdated at the moment. So many AGMs are taking place with regard to virtual platforms. So if you don't have a virtual platform and you're actually going to have a real meeting, yes, you do need voting cards. I also have to put a word of warning in now. On the virtual meetings, not many people who are running them, i.e. managing agents or even a trustee, are actually getting the voting right. There are voting apps that will take account of the PQ and that a member only has 1 vote, even if they've got 4 sections. And it's really important to do this. Otherwise, they're going to sit there manually. It could take 3 weeks for some people because managing agents are always busy. We know that. Otherwise, they're going to go home and they're going to try and work this out manually. And it doesn't work because anything could happen to those results. They could be doctored, some could be lost, whatever. So there are apps out there. One of the ones that I strongly recommend you use is MeetingPal. Excellent, created by a software engineer who actually knows sectional title inside out. And at that point, Billie's now going to get his chance.
Thank you, Shirley. So I'm going to have a look at what should be on the agenda. So the first point that we need to look at is the formalities. So we're going to have a look at some quorums, the different quorums. I saw that there were some questions about that. We're going to look at the pre-minutes, trustees reports, insurance, election of trustees, scheme rules, the domicilium, motions of matters for discussion, new and further business and closing. And the new and further business, that's Shirley's bane, and she hates that because then that makes the meeting from a 1 hour meeting to a 3 hour meeting. But unfortunately, we are required by law to have a discussion on new and further business. So as most of you guys are managing agents, you would know that we require a quorum of 33% of the people of the owners to be present or represented at the meeting to form a normal quorum. In respect of special resolutions, we need a normal quorum, so the 33% of the members, and then 75% of those members that are present and voting at that meeting to then vote in respect of that special resolution. Unanimous resolutions are slightly different. There we require a quorum of 80% of the owners present at the meeting, and then all people to vote in favor of that specific resolution. So those are the three different quorums that are required. So what happens where a quorum is not met? The matter then stands over for 7 days, same place, same time, and then whomever is present at that stage can then proceed, and a meeting can be held and the decisions can be made. There was just one aspect that I wanted to touch on as well. I just want to see if I can find that quickly here in Shirley's book. Where a special resolution is being made and there is not 50% of the owners present in respect of the owners that are part of the scheme, that decision will then stand over for a period of 7 days. People can object to it. If there are objections, then it needs to be taken back to a meeting, and at that stage, then whomever is there will then make the decision in respect of that. So where you wanted to have a special resolution and you did not have sufficient people, then obviously a special resolution can go forward, but on that basis then. An interesting question that we've been talking about on the sectional title group is people walking out of a meeting and then that there's no further quorum. There are opinions that state that once a quorum is formed, then there is a quorum, and whatever happens after that doesn't matter. I don't share that point of view. I think that the rules make it clear that we must make use of the common law of meetings in respect of meetings in body corporates. It's part of the rules. It does state so. And as such, the common law of meetings require that a quorum is present at all times when decisions are made. So once a decision is not, once a quorum is not any longer present, then that meeting stands to be adjourned to the next week, and the decisions must then be made at that stage. Okay, proxies, Shirley has touched on that. A proxy holder cannot represent more than 2 members. I understand my sound is still soft, so I don't know what's going on. I'm going to try and hold the microphone up at my mouth. I hope that is better. So Shirley touched on proxies and proxy holders, and the the rules state that proxy holders cannot represent more than 2 members. Where a member is the owner of more than one unit in a scheme, there obviously that proxy holder can then represent all those units, not necessarily only the 1 or 2 to a maximum of 2, but if the vote is count in numbers, then obviously even if you have 10 units, you have 1 vote, but if it's counted in value, then all the PQs of the 10 units are lumped together in respect of that vote. And a representative can represent all those units. So the Act in the rule specifically states that you cannot represent more than 2 members. We saw a big debate, I think yesterday on the group, where we saw that proxies were given to the managing agent. Obviously that is a big no-no. It is excluded in the Act. No managing agents or its employees may be nominated. So a definite no-no, and in that sense, that would not suffice in respect of a quorum, and would create some problems in that respect. Where properties is owned by more than 1 person, then those people need to nominate somebody to vote on behalf of the joint owners, and you would need a proper resolution in that respect. Exactly the same in respect of properties owned by companies or closed corporations. You would require a resolution to act on behalf of those companies. Okay, the chairman of the meeting, and we're talking about the general meeting or special general meeting. In practice, normally the chairperson of the trustees will act as the chairman. In many instances, they cannot or refuse to act as the rules or specifically say, and then the meeting will appoint somebody to act as the chairperson. In general, what we then see is that the managing agent would take lead and would chair that meeting. No problem with that at all. The obligation of the chairperson is to be impartial. He must make sure that everybody has the opportunity to speak their minds, and he must be independent. He must make sure that the meeting orderly. We see a lot of fighting at these meetings, and that is as a result of a chairperson not taking action and not making sure that people act in a proper manner. All the governance documents must be available at that meeting. And as I said, you apply the common law of meetings in that respect. So make sure that you then understand what your rights and obligations are in respect of that, and make sure that the meeting runs orderly. The chairperson also has a fiduciary duty, so must act in the interest of the group as a whole. If there are conflicts of interest, that must be declared, must not try and influence voting, must not say what he or she is going to vote for until the vote has taken place. If they then want to do so, then it's fine, it doesn't matter, but must not try and influence the vote by saying, I'm going to vote A, B, or C. The approval of the minutes, as Shirley said, minutes are approved. The previous meetings minutes are approved at that specific meeting. So if you had a special general meeting and now you have an AGM, then at the AGM, the special general meetings minutes will be approved. If it was your previous AGM and now you have got an AGM the year later, then you will approve those minutes at that meeting. It can be done prior to that as well, but you need to have minutes approved. Also need to deal with unfinished business that was standing over from previous meetings. So if a decision could not be made and this matter is still in the air and no decision has been made in that respect, that needs to be dealt with as well. Something very interesting.
Billy, can I stop you because now you're taking over my slides again?
Sorry, I just wanted to have a quick chat about the decisions of the trustees, but carry on. You go for it.
No, you're too enthusiastic. I need to backpedal because I see there's questions coming up. There is a mistake on the proxy slide. Can proxies be given to current trustees or MA? Definitely not to MA, but they can be given to trustees. I'm sorry that it came through like that, but yes, the trustees can vote as long take proxy as long as they only have 2. So sorry about that. I'm not sure which slide. It's slide 11.
Oh, I see. Managing agents.
Yeah, but managing agents, as you said, yeah,
absolutely correct.
Okay, so we need to approve minutes. I think that it's really important that issues that come up in previous minutes that haven't been decided need to come through, which the unfinished business is, because otherwise they get lost and a new set of trustees comes on and then nobody ever looks at the previous, they kind of forget that what happened in the past. So unfinished business was there for a reason, or business was on the agenda for a reason. Let's always make sure it finishes off. Did you want to add anything on that one, or can I go on with it?
No, go on. I just wanted to go back in respect of the decisions of trustees, something that you and I had a long discussion about yesterday. So I would want to have a chat about that as well.
All right. The management rules 17.6 is really interesting, and I have never read it that well. And I think that when you hear this, you're also going to get surprised. If the meeting is an annual general meeting, you need to receive reports of the activities and decisions of trustees since the previous general meeting, including reports of committees. Now, that really means that when you're doing the AGM, compiling the pack, you need to go and look at all the decisions that were taken at the trustees' meetings and put them into this report. I have to say I've got one block in Claremont that doesn't have trustees' meetings, so not sure what they'll have in their report. I don't know where anything happens either. But that is what they're saying. So the transparency that will come through is going to be enormous. Everything that's happened needs to be reported. And so it's the activities of the past and maybe the planned ones, the decisions made by trustees, as I said, all through the year. I mean, most body corporates have trustees meetings like at least once a month or every 2 months. And some trustees also have subcommittees where they're very large blocks, there's a lot going on. And those committees could be finance committee, building maintenance, security. All of that information also needs to filter through. And you know what it'll do? It'll show how much work the trustees really do, how much thought goes into it. It might give everybody a whole lot of calm feeling that it's not just arbitrary decisions being made. And the transparency, the more you give, the less questions there's going to be. It will stop a lot of the urban myths that go on. And Billy, would you like to add to that? Because you did want to say about the reports.
Yeah, I just wanted to say that the rule specifically also states that your minutes of all decisions, or your minute book, needs to be present as well at the AGM. So one will have to then, or you will be able to then correlate the decisions of the trustees to the minutes and to the minute book. And in that way, one ensures that a minute book is not altered after the fact. So when the decisions are tabled in this report and you say we have made the following decisions, and obviously not every little decision, make a payment in respect of the security company. I mean, that would not, I mean, I think we're talking about the important decisions made by the trustees. And those will be tabled in the report and form part of that report. And one can then always go back and make sure out of the minutes of the AGM that these were the decisions that were taken and they are minuted into the minute book as well. So as you said, I mean, it gives transparency, and I think that is what the Act requires.
Okay, thank you. And then we look at the consideration of the annual financial statements. There is no vote on the annual financial statements. And the reason being, as I mentioned earlier, is that the auditors are responsible for doing them. And the trustees who are whilst auditors are responsible for preparing them, they very easily opt out of the fact that they can't be responsible for everything. But the trustees are responsible for the running of the building. So they need to sign off saying, yes, they're happy with it. So the owners have not got enough inside information to actually vote for them. So there's no vote there. It's just to be considered. And there is no point in having an AGM without the financials, as I've mentioned before. It can be done, because if you don't have the financials approved, then you still have to approve them. So when they do come through, run all the other items that have got on the record, on the agenda, and then you have to call another special general meeting to approve the audited financial statement, which is a double cost, a double effort. So it's up to you as managing agents in particular to see that those auditors get those finances as quick as possible, because 4 months is a reasonable amount of time after year end. And if you're doing it every month, which most managing agents do, you should be able to get to the auditors and out within 4 months. So the appointment of an auditor has to be a 51% vote. I'd like to mention a few things about appointing auditors. First of all, it needs to be an auditor that is very used to dealing with sectional title or community schemes, because there's quite a lot of pertinent issues that arise specifically relating to sectional title and what goes into the accounts. So if you're going to change an auditor because the last one was expensive, which is the normal case, make sure you're going to compare apples with apples, and you're going to get everything that you need to do. Have done by him in the accounts. For examples, you have to have correct ones, because when a potential owner wants money, the bank are going to have to look at the audited financial statements. It gives a measure of security to all the owners that everything's being looked after. And I don't know if you're aware of it, but audits have to be qualified by auditors. So if you do not have a 10-year maintenance plan, or it's not correctly done, it's the auditor's obligation to qualify your audit, which means that it has to go into the report saying you haven't done this correctly. The auditor also needs to look at the outstanding levies and how long they're outstanding and what potential debts they are. They also need to put that the insurance has been paid and what the premium is, and make sure of that. They also rely, auditors are obliged, if they come across anything that's untoward or not quite right, to report it to their auditing body. So this is all more protection for the body corporate. So get the right auditors and don't just go on price. And honestly, from the owner's point of view, I'm just saying this, that sometimes if a managing agent doesn't do a good job of supporting the auditors with all the right documents and everything, then the auditors are going to be redoing some of the work. So then that can also run up costs. Okay, Billie, you're going to start with this, and then I'm going to talk about education. This is on slide 16.
Perfect. I just also want to say something about audit. The rules stipulate that there is no standard in respect of auditing.
That's good, yeah.
So that is a very controversial statement, or a statement that is made in the Sectional Title Schemes Management Act and the rules. Because the Audit Professions Act requires that all audits performed by an auditor in South Africa needs to comply with the standard set by their regulatory body in respect of audits. So we actually have a rule that are saying that we must act contrary to what a law states that should happen in South Africa. So to that extent, I believe that an audit of a body corporate should comply with IFRS if they are big enough, or IFRS for SMEs, And I am well aware that the audit professionals body is currently drafting, or they've just finished setting up a standard in respect of body corporates that all these audits have to comply with. So we are definitely going to see a more standard approach in respect of audits by auditors that are compliant with their regulatory body. So it's just something that I find very strange, that a rule in the Sectional Title Schemes Management Act are trying to overrule a law in a different act. So it was just something that I've picked up as well. Right, and then in respect of budgets, so Shirley and I had a long discussion yesterday about budgets, and I think she made a couple of valid points already in that regard. The budget needs to be drawn up by the trustees in conjunction or with the assistance of the managing agent, looking at your previous expenses, looking at what the reasonable expected increases will be, and then that should be built into the budget. That should then also be put through the participation quotas to determine what every levy will be paid, or what every unit will pay in respect of levy. So there will have to be a levy schedule. One will also have to work out what your reserve fund would be for the next financial year and what you need to recover in respect of that. That also needs to be accepted with a 51% majority for the budget to go through. So what I have seen during the days when I still managed the buildings was that one gets to a meeting and you have a budget that was drawn up and it shows that an increase of 18% is required. People then get up in arms and say, we are not going to accept that. We want a 5% increase. That's it. Or a 10% increase. That's what we can afford. And unfortunately, that is the wrong approach. So what I've done in that respect, then always in my meetings where I've chaired those meetings, I would say, right, thank you. I hear what you guys are saying. So let's deal with the budget. Let's start taking out that you don't want so that we can get your budget to the increase that you require. So can we take out the insurance? Can we take out the security company? No, we can't. So in that way, I've gone through the budget, and in general, one would find that people would then understand, but we cannot take out any of these items. By taking them out, I'm losing a service that I had. And at the end of the day, they would then accept, if that is the reasonable increase that is required, they would accept that. So I've found that is the way to deal with it. And not to just say, well, that is it, and end of the story. So go through it, make sure that you deal with each and every item. I mean, if you've got a municipal account where the increase by the municipality on common water or common property water will be 15%, then you say, well, that's the increase by Ekurhuleni. So do you want us not to have common property water? No, we need to put water in the pool. So therefore, it then makes it impossible for them to say, well, we can't accept it, because they must understand that that those are the expenses that needs to be paid by the body corporate. Maintenance, repair and replacement plan. Trustees can, obviously we need to have the 10-year maintenance plan in place. Then we're also discussing the increase of 10% by the trustees prior to the AGM in anticipation of an increase for the next year. That right the trustees have, that stays in place until the next AGM. So they can make that decision. They do have the right to make a resolution. Items that we find that are normally not included in a budget is a provision for bad debt. Now, we've also heard Shirley saying that auditors do look at that. In terms of IFRS 9, they are required to actually say what debts are impaired and what you expect not to collect. And therefore, it is one of their audit requirements to look at that, and they would say, well, if the debt is older than a year, I don't think we're going to collect it, and then the body corporate needs to start making provision that they will not recover that, and you need to have that in your budget then as well. Legal costs, something also that we find that are not in the budgets, specifically because the previous act made provision that all legal costs could be debited onto the account of the debtor. That no longer is possible. You can only debit the tax costs, which is a far lower scale than what the attorney would charge you, meaning that if the attorney charges you 120,000 Rand for a matter up to sale and execution of an immovable property, and you only can recover about 30,000 Rand in on a tax bill, then somebody else needs to pay for that 90,000 Rand, and those are the cost that is payable by the owners. So that comes out of the normal administrative budget, and as such, people or trustees need to budget for that, and it needs to go into the budget. Otherwise, they do not have money to spend in respect of that. Education, Shirley.
Well, I think education is becoming so key these days. You know, when you take on a role as a trustee, you're actually putting somebody else's ownership at risk if you don't know what you're doing. Because some of these buildings have so much turnover in the form of levies and then obviously payments. It's right running a small business. And yet it's not exactly right running a small business because you have to adhere to the sectional title legislation. So education is becoming more important. It is something that CSOS has started doing now. They do offer free education in certain categories. If you go to their website, they've got a lot of very nice videos. If you go to Stratafin's, they've got a lot of education going on there. The Linda, TVBM, wonderful. But there's basic things like books that you need to look up things right away. If you need to understand how to work out the levies, I think that you need to understand everything that is absolutely basic, not everything about everything sectional title. And it will make your relationship with your managing agent so much easier if you do understand the basics at least. So I do think that money should be put into education. There are a lot of courses out there. Some of them are much longer, some of them are much shorter. There's my book, which is going to give you access to finding out the answers to questions. But there's a wonderful one. Marina Constance has got a super one out. And this education needs to be provided. Just before you go to the AGM and you do your budget, go and see. It doesn't matter if you're not going to be a trustee, but whoever's going to be a trustee in the future is going to manage your ownership. So get the trustees up to speed as much as possible. So I don't think education has been provided for. I have in the past seen occasional times when they're going to send their gardeners on a course of gardening or maybe on the OSH Act. But this is education for trustees, which is imperative. It's legislated, you have to do it. And even if it's 10,000 Rand, you're going to do quite a lot with 10,000 Rand. If it's 20,000 Rand, even better. But whatever it is, do your due diligence and put it into your budget.
I can also just say, as part of the resources that we are going to make available, and we've done this before, we are going to make available again a budget template, which is an Excel template that will assist you guys in drafting a proper budget, where you look at your previous year's expenses and then estimate the increase for the current year. That will work out the budget for you. It will work out the PQs for you and so forth. So that will be available on the free resources to you guys again today. Okay, insurance. I think we need to get Mike Addison to have a webinar with us on insurance, because I think we need to get some detail expertise in this regard. But I've had a couple of points that I wanted to just mention. Obviously, we are required in terms of the Act to have body corporates required to have fidelity cover. The amount of the fidelity cover is determined by the members at the AGM. So that needs to be discussed at that AGM, and a decision needs to be made what they want to insure. The fidelity cover covers the loss of the BC's funds as a result of fraud by the trustees, the managing agents, and employees, in short. So one need to go and have a look at your bank account, how much money is in a bank account at any given stage, and then make a decision to what extent you want to protect that. There's ways of protecting it, obviously, by setting up the rights in respect of the account in such a way that somebody can't release the money on its own, limit the amount that can be released, and so forth. And taking all of that into consideration, one will then determine what fidelity cover will be taken by the body corporate. You're also required to take out public liability cover. This is also determined by the members in respect of covers for bodily injury and death. So the members must determine what they want to insure, what the amount is. In respect of damages and loss to property, the Act at the moment, or the rules at the moment, require a minimum of 10 million rand. But that is also the minimum, so that amount can also be discussed and changed at the AGM. In respect of the units, we need to have a schedule of replacement values that must be valued every 3 years and must then be presented to the AGM. The insurance that are taken out must restrict average, so that means that the insurance company can't apply average to these units and not pay out what was insured for. And where a bank in general asks for a higher insured amount to cover their bond, that member will be responsible for that additional amount. And members are also, in respect of excess, responsible for excess payable in respect of their units.
Willie, can I just add into something? Sorry, I'm interjecting, but I just have 2 strong points here. One, these days, because of virtual meetings and brokers being accessible, get your broker to come to an AGM and talk through the insurance. That's the best advice you can get, and all your questions will be answered. It's a very, very useful way. And please be aware that cybercrime, hijacking of information, undercopy, and so on needs to be covered, and not all the insurance policies are doing it. So investigate that.
Shirley, am I doing the number of trustees?
It says both here.
Yeah.
So okay, I'll start and you can do the directions.
There you go.
Okay, determine the number of trustees. It's really important to decide how many you really work well with, because some body corporates work better with 5 and some with 7 and some with 3. But at the end of the day, whoever the trustees are, they need to be working people. There's no point in having 10 trustees and most of them don't pitch up the meetings and they're not available to do round-robin resolutions, and it completely throws out the voting at trustee meetings. So 3 hardworking ones would be a whole lot better than a whole lot of deadwood. And so when you as an owner are voting for trustees, take that into account. Have they got a track record of working hard? Have they got a track record of being difficult or otherwise, or whatever, make up trustees? Because people become trustees for totally different reasons. And the other thing is, I always find it a good idea to ask the people that are being nominated to stand up and say a little bit about themselves. Have they got any experience? What is their background that they could bring to manage the body corporates in certain areas? Why do they want to be a trustee? They are going to be managing our future, our investment, our owner, our own unit. So let's get the best we can. And so when it comes to election of trustees, then the people that are best should actually be voted for. And you can't vote for people if you don't know really what their true intentions are or what they can really contribute to a very difficult situation. Running bodies corporate is not easy. So that's all I'm going to say on election of trustees. How many you need is up to you and how it's worked in the past. And Willie's going to do giving of directions and restrictions.
Yes, and the other thing I want to say regarding trustees is also that trust people that you can trust. I think that is important, that you pick people that you actually can trust and that you know that are going to work for the scheme and that are not there for their own interest, but for the interest of the scheme. It is important. I mean, we see so many posts on all the different forums about trustees running schemes for their own benefit and people complaining about it. So it's very, very important that owners know that they have the right to choose who those people are that going to be the executives of their scheme, and make sure that they trust those people that they elect. And I think that is the most important thing. Then the other thing, obviously, is even though you trust people, you want to give them directions and you want to give them restrictions. So it is also important that that is considered very carefully to make sure that you know what restrictions you want to put in place. Make sure that you put restrictions in place that are not going to hamper the work of the trustees. For example, put a restriction in place that says no amount exceeding 5,000 Rand may be spent on a specific item. And knowing that it costs on average 15,000 Rand to do a specific repair. All that will do is it will hamper the hands of the trustees. It will make them act outside of their mandate. So make sure that when you put the restrictions on them, that those restrictions are fair restrictions, but that those restrictions are there to ensure compliance and good governance. And use your previous year's expenditure to determine those reasonable amounts and the directions that you want to give to them in respect of what they should do and shouldn't do. Okay. One of the other items that needs to be discussed also is any amendments to the rules. Obviously, that needs to be placed in front of an AGM and it needs to be considered, and the necessary quorum needs to be reached for those rules to be changed. So that needs to form part of every agenda in respect of your AGM. Your domicilium, I find a lot of body corporates have moved from one managing agent to the other, never changed the domicilium sitandi et executandi of the body corporate, and that places the body corporate at risk in respect of litigation. In terms of our law, a summons can be served at the domicilium sitandi et executandi, and that service, even if that's not your address anymore, that service is regarded as proper service in our law. So as a managing agent, make sure that that is changed to the managing agent's address, the current managing agent's address as soon as possible, so that you are aware when any process is served on the body corporate and you are aware of any litigation or pending litigation. I cannot tell you how many body corporates that we are dealing with have as a domicilium the address of a managing agent that were 3 or 4 times back the managing agent. So it's a very important thing, and make sure that it's on the agenda and that is changed. Obviously, we also need to discuss in terms of Rule 17.4 matters that were standing over or that were brought in front of the AGM by members or bondholders. So here we've had 25% of members that have said we want a meeting, and this is what we want to discuss. So that needs to be on the agenda as they have required it to be on the agenda, and that needs to be discussed at that AGM. Okay, then I've also discussed the matters brought forward. I mean, obviously we need to discuss those and we need to see if we can finalize those matters as well. So these are all the matters that needs to be on an agenda. I see we are running out of time already, so I've just gone over the last ones very quickly, but there are also some of these in our training that we have discussed yesterday, Shirley and myself, and where we said in future we are going to go into depth into certain aspects. For example, we will just do a whole webinar on quorums and so forth. So we will look at some of these more in depth. Once the meeting is finished, then obviously the chairperson needs to dissolve that meeting, record the time when it's closed. That then brings the meeting to an end. So I think at that, with that, we're also almost at the end of our meeting or the webinar. We're going to have Shirley that do a giveaway. So I'm going to give over to you, Shirley, to have a chat about your giveaway.
Okay, thank you, Baillie. I just want to say that I do basic training. I don't do fancy training, but grassroots level training. It starts off trustees to understand. It starts up managing agents, perhaps the junior ones in the office, but I can do a more senior. So, and there's always people saying, oh, I need some more information on how to deal with CSOS, or trustees come into power and then they don't know how to start it, even if there are resources like Ballie's got on his. So what I'm giving away now, which covers what I do, is that I'll give you 2 hours. One person will get 2 hours of training on any basic aspect of sectional title, which you would like to understand better. And you can choose 2 other people to come with you, and we'll do it on virtual. And you can give me the list of questions beforehand. We'll give you that. So that's the first prize. I think that's, Daniela, are you going to draw them now or at the end?
Yeah, I've got the list now. Let's draw one name for the first giveaway. I'm just going to do a random number generator and just pick a name. Okay, so the first one is Kogi Naidu. I'm sorry if I've said that incorrectly. Kogi, I'm going to send you an email after this, just with the details of your prize, and hopefully you enjoy it.
The next present gift I'm giving away is a publication that I do of 6 to 8 pages, which is called Introducing You to the World of Sectional Title. It is written in a way that you can understand the key elements. It's like a jigsaw puzzle. All the little elements go together. It's written easily, simple to understand. It uses the terminology that people need to know if they're living in sectional title or they're working with it, or they're the receptionist at a company that deals with it, the basics. It's really, we brand it with either the body corporate's logo, very nice for welcome packs and to go with the conduct rules, very informative, it sets them up. Or if managing agents want to use it as a marketing tool and at the same time educate those out there, you're welcome to do that. So who's the winner of this?
Okay, the second name that I pulled out of the hat was Paul Ash. Paul, I will also send you an email with your giveaway.
And just to encourage people to use this keyword access to the Sectional Title Act, I think Willie's going to hold it up there. You can look up anything, any aspect you want to in less than 60 seconds. It's a really, thank you, Willie, it's very easy to look up. I did it because I used to have open book exams, which didn't help at all because I couldn't find anything in the 3 hours allotted. So hence my start of my keyword access book. It is an investment. That is why I say you need to put it away. So thank you to Nola Kotza. That you need to put it into the trustees library. I'm offering 300 Rand discount on every book manual purchase if you pay for it by the 15th of August if you've attended this. The full price is 1,600, so so it'll be 1,300, which is a very nice discount, and it will be the best investment you've made for your body corporate for a long time. Anything you want to say? You're waving it around.
No, I want to say, Shirley, is that we use this every day in our office. So there's a fight about this book on whose desk it's lying. So everybody is fighting, and as you can see, I mean, we've got all the tags in here. Obviously, you don't really need the tags, but it just makes it so much easier if you've already looked at something to quickly get it again. But it's obviously, it's such a super book, and I mean, it's something that everybody should have.
So do it. And all these compliments coming in. Thank you very much indeed. So get your 300 rand discount, because I don't discount the books very often. I think that it's a very good investment. So, you know, one doesn't always discount good investment. So go for it. Let us have your orders in. Okay. And thank you for all the messages. I do appreciate it. I also thank you very much, Willie and Daniela, for letting me be part of this. Thank you so much.
Thank you for being part of this, guys. From Stratafin's side, we're also going to give away some free resources again. We're going to give out templates on notices, on agendas, on minutes, on proxy forms, nomination forms. We're going to give, there was a question about voting cards. We're going to give out a voting card. There's no specific form in respect of voting cards. So obviously, as long as you can prove what was voted and what the vote was, then that's sufficient. We're going to give out the budget spreadsheet again, and some trustees resolutions that will be available, that we will email, and we will also make it available on our website again. And then I just want to quickly say, from Stratafin's point of view, Stratafin assists body corporates and homeowners associations who has financial problems. We do so with a unique model. Our model is completely different from the models that are in the sectional title arena prior to Stratafin. We have a model where we take over the debt of the body corporate. The body corporate immediately gets access to cash flow. There are no repayment by the paying owners on a monthly basis. So money is immediately in their coffers, and we take over the risk of the collection as well as the cost of the collection. So a completely different model than what is currently available or from the other service providers. And we believe that this model does not put your body corporate into a debt trap where you are borrowing money that is then connected to a loan and to the outstanding levies, and those outstanding levies never get collected. And as long as it's not collected, you will keep on paying interest. So we have looked at that model and specifically rejected it and decided to go the way we're going, so that we can give a fair and equitable model to bodies corporate to get some cash flow. Thanks.
So thank you, everyone. I see there are tons of questions that are still sitting here. We just unfortunately have not been able to get around to everyone's question. Marlisa's been working furiously trying to answer all the questions. So we will take the questions past this, and we will respond to them and then send out the answers to everyone. So, and what you'll also receive after the email, after the webinar, is an email where you will have access to the recording of this, plus the slides that we've got here today, and access to all the resources that we've spoken about. So thank you so much. And thank you, Shirley. Thanks for being part of this. We really appreciate it.
I've loved it. Thank you so much.
Okay, great. Thanks, everyone.
Thank you, guys.
Bye-bye.
Bye.
Bye-bye.